Hey everyone, Harry here to talk about Donald Trump's failed last-ditch attempt to try to remove his New York case, the case on which he is scheduled to be sentenced in 2 weeks, to federal court. Okay, let's just take a step back. So he's been convicted, and he previously tried unsuccessfully to remove the case from state court to federal court. Removal, you can do it for a criminal court case. Basically, it's sort of an antiquated idea, but it's still on the books. Especially early on in the Republic, there's a real fear that federal officials will be hounded by state types, really when they're just executing federal policy, just doing their jobs, and the hostility of the states to federal policy rather than to any kind of criminal conduct that a federal official has done could lead them to bring a criminal charge. So because of that prospect, we have removal, which can be done in other cases, civil cases, but there's a special procedure here, a criminal case, that it's brought in state court and you ask to remove it to federal court. You have to make certain showings, and all these showings here under removal, under the Westfall Act, which is about when will the DOJ step into the shoes of a federal official who's been sued. And now the immunity case, they all swirl around this notion. Was Trump basically doing his job, or was he not acting as president, but just acting as a private person and breaking the criminal law to boot? So that's what he basically needs to show, that he was acting under color of law, he has a federal defense, and the like. The case is still live, right? The trial is over, but sentencing is set for the 18th, so it's technically okay to try to move. Of course, he tried to move before, and he lost, so that's a problem. And he also then waived it thereafter, or at least abandoned an appeal in the Second Circuit, and that's a problem. But he's, I think, angling for anything he can do, perhaps to get it up to his warm compadres I shouldn't really put it that way, to the justices of the U.S. Supreme Court, and it is, I think, gauged to try, and this is what he's doing in every single way, trying to not have this sentencing happen on the 18th of September, trying in a close race not to have a court pronounce some sentence, which could include jail time. They would not make him go to jail right away, but they could say, Mr. Trump, you get jail for this. And that, we surmise, as do both campaigns, that would be a real political hit for him. When he was actually convicted of the 34 counts in New York, that was a political hit. So the game here for him is to try to get out of sentencing. He's made a third motion to Mayor Chun saying you should recuse yourself because your daughter worked for a political consulting firm that had Democratic clients, things like that, and nothing is sticking because nothing is meritorious. Okay, but here he does again another removal motion, and that means it goes immediately into the federal court that has to make a prompt disposition. Was this basically him acting in his official capacity? And remember what we're talking about here, the payment of hush money to Stormy Daniels, a porn star, to cover up a one-night stand that would have injured his campaign that was already on the ropes from similar allegations just on the eve of the 2016 election. So that's the conduct basically. And I say basically because in a removal case, you ask generally if the conduct is official or under color of law and the like. And I'll get back to the extra step you would have to take for immunity. Okay. So it goes to the federal court that's in the same district as Mayor Chun, and he gives it very, very short shrift, like, it's sort of a "are you kidding me" type opinion. So Trump actually brings two claims. He again trots out this old stale idea about the daughter and says that somehow he should have recused himself and there was bias. And Hellerstein properly says that's not a basis for removal. That's not, you bring that up to the state court. The second thing he says, though, is, again, because of the immunity opinion, he should have immunity from protection under federal law, and therefore you need to take the case or dismiss the case. By the way, I've said this before, but removal is a little bit of a confusing concept. If it goes into federal court, it's the same case, same law, state law, etc., but the federal court, even a jury, has to apply it. So it's just a different venue. Anyway, Hellerstein has no problem saying, look, in Trump, we had 3 categories in the Supreme Court opinion. I'll analyze it if quickly. It reads as if he, dictated it in the last 15 minutes of a lunch break, but he talks about the immunity opinion, and that means core conduct protected, official but not core, presumptively immune, and then unofficial, not immune. And he just goes right to it. Look, I've already said this, parties. Hush money paid to an adult film star is not related to a president's official acts. It does not reflect in any way the color of the president's official duties. I did this after an evidentiary hearing. The New York DA showed conclusively what was going on here and what it was about. So you can just look at the face of the notice and know that removal should not be permitted. This is, clearly about conduct that just can't be said to be under color of law. Boom, full stop, no removal. But Trump already, I think he had to anticipate this. And in fact, he has to anticipate that it's just not a strong claim, but he files a appeal to the Second Circuit, right? You go to the district court, the federal district court, to try to get removal. Very quickly, Hellerstein says no. He's going to take it to the Second Circuit. And the game here is he hopes, and he's timed it out. He could bring it any time because he's already brought it. Really, it should be dismissed for that basis. But his hope is that it is in front of the U.S. Supreme Court on or around the 18th, and that they do that same old trick that they did in the immunity case, namely grant a stay while they think about it. And if he can just get past the 18th, if they're granting a stay while they think about it, then the complications of rescheduling he's counting on enough to get him over the finish line to November, which is really what he's trying to do. So he knew he was going to lose this. It will depend perhaps, but I don't see much chance in the Second Circuit. And he's rolling the dice, both on substance, how they'll decide it, but also and timing. He's trying to game the calendar so that this appeal from the denial of removal is in front of the U.S. Supreme Court just around the 18th of September, and they grant a stay, which you can do without any explanation just while you're considering it, and then boom, no sentencing September 18th. So that is the game here. We'll see if it succeeds. It would be, outrage piled upon outrage to interrupt this state court prosecution now, the way they totally paralyzed the federal court one. But I think that is what's going on, and it's now in front of the Second Circuit. We'll see how quickly they dispose of it. But then for Trump, the main event, hopefully another warm reception at the U.S. Supreme Court. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.